Good evening. Welcome to our presentation titled Legal Advice on Property Buying and Renting, which is part of our Many Matters series here at the Champaign Public Library. I'm Eva Liu, a reference librarian at the library. Thank you for joining us tonight. I would like to introduce our presenter for the evening, Joe Souligne. Joe is a University of Illinois graduate. He got his bachelor degree and JD at U of I. He is associate attorney at the Webber Thies PC in Urbana. Joe's focus is practice in the area of real estate transaction, business representation, and general litigation. He is also an ambassador with the Chambana Welcome Crew, a member of the Young Professionals of Champaign-Urbana, as well as a graduate of the Emerging Community Leader Program of the United Way of the Champaign County. Joe, thank you for being with us tonight. So please help me welcome Joe. Thank you.
Thank you, guys. I'm glad to be here. First off, if I'm too loud or too quiet, just raise your hand, let me know, yell at me, whatever. And second of all, if you have any questions, same thing, feel free to raise your hand or just grab my attention. I'll also try to save a few minutes at the end for questions if there's anything else, but I'm happy to take them as I go if you think of anything or if there's anything that, that comes up. So as we said, we're just talking about leasing and buying real estate. These are going to focus more on the tenant and the buyer portion. I might mention a few things about the landlord side or selling, but this is mostly going to be focused on that side of it. So first off, let's kick off with leasing and being a tenant in a property. So first of all, what is a lease? A lease is just a contract. It's just like any other legal contract that you might enter into. So it doesn't have any special designation or anything like that. You can enter into it just like you can a contract with, a builder or with a garbage man, any kind of contract. It has the exact same effects. So what does that mean that it's a contract? So first, it is a legally binding document. So once you've signed a lease, you are bound by the terms of the lease, whatever those might be. So, just because you sign it and then you change your mind later on, that doesn't mean that you can, get out of it or change your mind. You've signed the contract and you're bound by those terms unless you come to a different agreement with the landlord. So as I said, that also usually means that there are penalties of some kind for violating the terms of the lease or breaking or defaulting. Those are the same thing for basically breaking the lease. And those penalties could be, they're usually going to be monetary. So it could be, in terms of a certain amount of rent or a percentage. If you damage the property, that's a violation of the lease, things like that. And then the last point, so generally a lease will take effect immediately, even if you're taking possession in the future. So especially around Champaign-Urbana, we have a pretty unique rental community here because of the university and the large number of students that we have. So I know a lot of properties here are leased well in advance of when the tenancy actually starts. So for example, you might be signing a lease even as early as, say, September or October of 1 year for the next August. Now, even though you are not moving into that property until the next August, you are still bound by the lease as soon as you sign it. So if I sign a lease now that says I'm not going to move in until January of next year, even if between now and then something changes, I have to move. If you're a student and say you drop out of the university, unless the lease has a clause that lets you get out of it if something changes or if certain events happen, chances are you're still going to be bound by that lease. And you'll have to either pay some sort of rent or something like that to the landlord to get out of that lease. So make sure before you sign it that you're confident that you'll either live there, or if something changes, you can take care of that and you have backup plans in place. And oral leases can also be enforceable. And oral leases doesn't just mean spoken. So that could be a text. You know, say you text your friend and say, hey, I need a place to live. Can I crash in your spare room for a couple months? And they say, yeah, that's fine. You know, pay me $200 a month and half the utilities. And you say, great, and you both agree on that. That can still be a lease. So then if your friend comes back and after a week says, hey, you need to move out, you could say, well, we agreed on this. I have a lease. You can't kick me out. Now, in that situation, might be better to try to work something out because you probably don't want to be living somewhere where somebody doesn't want you. But legally, if he tried to take you to court, say, you probably have a lease that you could enforce. So it doesn't, you know, when you think of a lease, you might think of a long document with all kinds of clauses and stuff like that. It doesn't have to have all of those things to be a lease. So there can be a lot of things. Basically, as long as it provides how much you're paying or any terms for you living somewhere for a certain amount of time, that can be a lease. So again, because a lease is just a contract like anything else, it really can encompass any kinds of terms that you can think of. There could be rules about living in the property. You know, quiet hours is one, especially around here with students. All those kinds of things can be in a lease. But these are a few terms that you're going to see in almost every lease. So the first one, joint and several liability, is a fancy legal term that basically means if you have multiple people signing the lease, so say you have 2 other roommates that you're living with, if you all sign a lease together and that lease states that it will have joint and several liability for each of the people signing, that any one of those people can be held responsible for the entire amount due under the lease. So say your rent is $900, you have 3 people living in the apartment, and you've all agreed between each other that you're gonna pay $300 each, you know, just evenly split. If the lease contains a clause that says joint and several liability, and one roommate moves out, the landlord doesn't get to say, oh, well, you only owe me $300 because it was supposed to be split 3 ways. The landlord can still make the 2 people left pay the full $900. And if they take you to court, if they try to evict you, even just one of those roommates could still owe that full amount. So now then they have the opportunity to try to go after their roommates, and that's kind of beyond the scope of this presentation. But just know that if you sign a lease with multiple other people and it contains joint and several liability, you could be held responsible by yourself for that whole amount of the lease. Next up, security and damage deposits. Most people are probably familiar with these. Typical would be like 1 month's rent or a few $100s. Those deposits are then held by the landlord throughout the term of the lease, and then once the tenant moves out, they use that to fix anything that might have been damaged or deteriorated, anything like that because of the tenant living there. Now, they cannot deduct you for anything that is normal wear and tear. So say you move into an apartment that has brand new carpet, you live there for 5 years, and then once you move out, the carpet has obviously worn out a little bit by that time. They can't charge you and say, oh, well, it had new carpet when you moved in, so you have to pay for brand new carpet. Normal wear and tear cannot be taken out and held against the tenant. But if you, say, put a hole in the wall or something like that, or there's a microwave and when you move out it doesn't work, that's the kind of thing that they would deduct out of your security deposit to replace those items or fix those items, things like that. Another thing here that could come up is painting. A lot of leases will provide that you have to return the apartment in the same condition as when you took possession. So if you move into an apartment and it has white walls everywhere, and you paint one of the bedrooms blue and another one yellow, a landlord usually can either require that you paint it back at the end or that they can deduct to paint it back themselves.
What if the damages are most likely more than the security?
Yeah, so the liability is not limited to the security deposit. So usually that's an amount that they're just holding as, kind of that protection. But if your security deposit is $500 and you do $1,000 worth of damage to the apartment, the landlord can still sue you or come after you for the rest of that amount. So yeah, that's an important point to note. That's not a limit. So don't think, oh, well, I've already done more damage to this apartment than my security deposit, so might as well just keep going. Yeah, doesn't work like that, unfortunately. And then that actually leads into the last clause, which is the attorney's fees. So most leases are going to have clauses that say if the landlord has to sue you, either to evict you or for damages, anything like that, that if they win, you are also responsible for paying the landlord's attorney's fees. And that is a sticky clause because that is where things can get expensive very quickly. And why a lot of landlords, even if it's a seemingly small amount, could still come after you in small claims court or something like that over those amounts, because if they win and they get a judgment, those attorney's fees are then owed. So really there's no downside for them. And it could take a small bill into a very large bill very quickly. So make sure if your lease has an attorney's fees clause that you are familiar with it and that you're proactive about dealing with any issues so you don't incur those attorney's fees. So in particular, Urbana has a special landlord-tenant ordinance, and these are just a few of the terms. There are extras, other terms and protections that are in place specifically in Urbana. And other, specific municipalities might have their own. Champaign does not have anything in particular, but Urbana does. So just a few of them. 5% limit on late rent fees in most cases. If the landlord can show that they incurred actual damages more than that 5%, they can charge those. But there has to be some sort of actual economic harm that they suffered because of that. And that also has to be in the lease. The amount of the late fee or the percentage or however they're calculating that has to be in the lease when they sign that. Additionally, a landlord cannot completely prohibit a sublease. Now they can have conditions in terms of, a proposed subleaser has to apply or they have to pass a credit check, things like that. So next up, the contract will also state a date of possession and closing. Generally, it's a month to a month and a half out from when the offer's made, just to provide time to kind of go through the process, but it could be at any point in the future. We actually have one person who signed a contract to close in December of this year because they know that they're going to be moving later in the year. The people they're buying from are not ready to move out until later in the year, so they've already signed the contract, but they're not closing until December. So that's flexible, but I would say generally a month, 2 months is the normal range. The contract also provides rights to inspections and to the condition of the property. And I'll talk a little bit about inspections on the next slide. But the standard contract does protect you that the seller is usually warranting what the conditions of the property will be and that the major systems will work. So that, the heating, the plumbing, electrical, things like that, under most contracts, those are warranted so that if you find something isn't working, the seller is the one who's responsible for fixing that. There's also personal property that can be transferred along with the property, and that is that could be like furniture, things like that, but that's also appliances. Those are not considered part of the house. So if you're buying a house and you say, well, I want the fridge and the dishwasher and the oven to stay with the house, that should be listed in the contract. And then finally, contingencies. So two of the main contingencies would be financing and sale of another property. So for example, if you are getting a mortgage, you want to make sure that your contract says, if for some reason I don't get that mortgage, I'm not approved by the bank, then we can cancel this contract and I'm not required to go through with it when I don't have the money from the bank. So that's a fairly normal one. The other one that comes up not quite as often, but is definitely not uncommon to see, is sale of another property. So somebody's selling their other house and they say, well, I want to buy this house, but I can't do it until I sell my other house first. So you can say, great, we've already signed a contract, but if something happens, that sale falls through, then I can also walk away from this purchase. So I mentioned inspections before. These are a few of the types of inspections that you'll normally see. Whole home is kind of just the catch-all inspection. That's where the inspector will come to your house and look at, the electrical wiring and the plumbing and things like that. They're obviously not going to tear open walls to check every last inch, but they'll check, they'll do as thorough a job as they can. The one caveat I always give people is if you get a whole home inspection, your inspection report is going to be 20 pages plus of every little thing that they say, look at this, or have someone look at this, or have someone look at this. This needs to be inspected. It's going to look really scary, and it's really not as bad as it looks. They obviously want you to know every single thing that could be a problem, just in case. But it's usually only one or two things that come up that could be an issue. And usually the process is you would turn those over to the seller and say, these are the changes or the fixes that I request be made before closing. And then they can either make those changes, they can give you a closing cost credit, or you can negotiate from there. There are also radon inspections. So radon is just a substance that's in the ground. Usually homes that have basements might have elevated levels of radon. And there's just some remediation efforts that are a couple $1,000s usually that they undertake if they find that you have elevated levels. So not everyone has a radon inspection. It's up to the buyer usually if they want to, but that is something that is common. If you have a well or a septic tank on the property, sometimes you'll have those inspected to make sure that those are in working order. Obviously, if you're in town, you might not have either of those things. And finally, a termite inspection. And again, the contract will usually address if we do find issues with a termite infestation, how are we handling that? Is the seller paying for 100% of that? Are we going to split that cost or, up to a certain amount? Things like that. So here's where I was going to bring up the Airbnbs. So associations and other restrictions on your property. Usually, especially if you're working with a realtor or when you make an offer, you can ask the seller usually if the property is part of a homeowners association. Homeowners associations usually are in place for whole neighborhoods or things like that. And a lot of times we'll have rules either on how you can build your house or, fences. Some of them could even say what colors you can paint your house, things like that. It can go on and on and on. So that's something you usually want to know before you buy a house, whether or not it's in any kind of association like that. Because there are usually also dues that could be monthly, yearly, things like that. So that's an extra cost that you need to plan for. Usually those homeowners associations are provided for in covenants that are recorded on the property. So similar to how a deed gets recorded with the recorder's office, they'll record covenants that attach to a property and say you can't do this on this property, or you have to build at least this big of a house on this property, or things like that. So again, that's something that you can usually get a copy of before you complete the purchase, so you know if there are any restrictions that might be an issue. And finally, easements. Usually these aren't a problem. There's all kinds of easements for utilities or things like that, if, say the power company needs to come on your property to fix a power line, they can do that because they have an easement. The only case where I would think it might be an issue is, say, it comes up a lot in rural properties. Say that there's a neighbor who has a piece of property that they can't get to off the road. They might have an easement that they're allowed to use part of your driveway, to get there or something like that. And that's also something that would be recorded and you could find out before you complete the purchase. And I mentioned Airbnbs, so a lot of homeowners associations will also have rules that might regulate rental properties in that area. So they could say no Airbnbs, or they could say no rentals at all. I'd say it's probably uncommon to find that restrictive of a rule, but some might say no more than 20% of our properties can be rented out, things like that. So how do you find out about all those things that might be recorded on your property? They would show up in the title insurance report. And so what is title insurance? And it is essentially an insurance policy, just like your car insurance or homeowner's insurance or anything like that. So when you sign a contract to buy a property, 99% of the time, it's going to provide for title insurance. And title insurance is where a company who does this as their main business will go through the public records for that property and look and see, are there any covenants that are recorded for that property? Are there any easements? Are all the taxes paid? Are there any mechanics liens? So say you have someone come out and fix the plumbing on your house, and then you don't pay them, that plumber usually has a right to record a lien on your property. And that lien says that before you can sell this property, I have to get paid. Theoretically, that person could then foreclose just like a bank could. A mortgage is also a lien on your property, so this is similar. And so what a title insurance policy does is they go through, they check all the public records, they check everything else that's public information, and they certify to you that there are no liens on the property that would affect your ownership. If you're getting a mortgage, the mortgage lender is going to require that you get title insurance, and there are very, very rare cases where I would ever say that it's okay to buy a property without it, because it's just that peace of mind that you know there are no issues with this property. Now, in the rare instance that you get title insurance and then an issue comes up later, it works just like an insurance policy. So say you buy a piece of property and then someone comes down the road and says, oh no, I actually bought this property 5 years ago. I own this, not you. You call your title insurance company and you say, hey, I've got this issue. This person is claiming that they own my property. And they will either pay out a certain amount, which is the insurance, the claim amount, and then you could use that to hire an attorney to defend your property interest, or they will get an attorney on your behalf, similar to how a car insurance company would if you were in a car accident. So works just like insurance, and it's just that peace of mind that there's no one else out there that's gonna say you owe them money because you bought this property or anything like that. You own this property free and clear after you buy it. So then once you've made, oh, yeah.
Question. Once a home mortgage is paid off, can scammers come in and try to take the deed to the home? How can a person be protected that once they paid it off, it's theirs and that's it?
Yeah, so the nice thing about property deeds is that they are not like car titles, say. So when you have a car title, the piece of paper is the actual thing that says you own that, right? A property deed is not like that. The piece of paper that gets recorded is just a piece of paper. What really matters is the recorder's office, which here in Champaign is over in Brookins Administration Center in Urbana, that they keep a public record of who owns every property. So every single deed that gets recorded, every single mortgage, every single lien, all gets recorded there at the recorder's office. So someone can go in and record, so let me back up. When you pay off your mortgage, the mortgage company will send a release of lien that gets recorded. They send it to the recorder's office. Yep. So the mortgage company will send that. That'll get recorded on your property, but your deed is still there. So that deed already says you own the property. And the mortgage is just like a modification to that. But your deed is still there.
So nobody can come in and say, okay.
Nope. So if someone else tries to record something on your property, you can show that it's illegitimate and get it taken off or thrown out or, yep. So like theoretically, I could go try to record a deed, for your property. But then if somebody finds out I did that, if you find out I did that, you can say, hey, this isn't legitimate and sue me, and then I owe you money or I go to jail for, lying, for filing a false deed. So, yep. So there are protections for that, but yeah, it's there are laws that prevent filing deeds for things that aren't true, and things like that.
One other question.
Yeah.
Once a person has lived in a home like 10 years or so, when should they do another inspection?
That's really up to them. So that's just a part of normal maintenance. So if you want, an inspection could be a way to find out just, hey, what are all the things that I need to do to upkeep my property? But there's no set time. I don't think most people would hire an inspector to do that. They would probably just have individual, like an HVAC person come out and say, can you look at my furnace and air conditioning and make sure it's all running okay? Yeah.
Kind of adjacent to her question, even if you lived in the home for like 10 years, 15, whatever, but now you're thinking about, you bought another home, you're thinking about renting that one out, would it then be like more of an incentive to do like a new whole home inspection or what have you, because now you're thinking about renting it?
You could, especially if you thought that might help renters feel peace of mind knowing that a property. So if you think renters might be worried about that, you could say, hey, I've had it inspected, there were no issues. I can't say.
Not necessary.
No, I don't think it's necessary. Yeah, usually the inspections are just done when you're buying so that there's no issues that need to be taken care of before that. I think an inspector will come out anytime you want them to, that there's nothing that would stop you. But I don't think that that's anything necessary or anything like that. So after you've made it through the whole purchasing process, you've found out that you have clear title, and you get to the closing, which is the final part. So the MLS contract provides a right for buyers to do a final walkthrough in the usually 48 or 72 hours right before the closing. And that's your chance to go back into the house and make sure that everything looks the same as when you made your offer or first saw the property. So you usually walk through. If there were any repairs that you requested to be made, that's your chance to double check and make sure that they were made. Just make sure that nothing else has changed on the property, that all the appliances still work, all those kinds of things. If they don't, then you want to bring it up before the closing or at the closing and make sure that you're working that out. But assuming everything goes right, then you go to the closing. Usually those are held at the title company who issue the title insurance policy. Your lender might be there if you're getting a mortgage to go through those mortgage documents. If you have an attorney, they'll usually be there. Your realtor might be there. But the buyer and seller sit in the same room. They sign all the documents. The title company has documents to make sure that they're clearing that there's no liens. The buyer is signing all the mortgage documents and things like that, saying that nothing has changed, your loan application, all that information is still correct. If you're buying, you should be ready to sign a lot of documents. It's usually a real thick stack. But yeah, so then you go to the closing, and once you walk out of there, they send the deed off to be recorded, and you own the property. So, yeah.
Is it necessary to get a realtor to help you sell the home, or can you do a personal for sale by owner or something like that?
So it's definitely it's not required in any way. Either buyers or sellers can work with or without a realtor. It's their choice. I'll say, so generally the way it works, and this is also something that could be negotiated between the parties in an offer to buy, but usually the way it works is that the seller will pay the realtor's commissions for both themselves and the buyers if they both have one. So the standard in Champaign County is usually 6% is the realtor's commission, and if both parties have a realtor, usually that'll get split between them, so they'll each get 3%. Now, every so often there could be a seller who's selling, for sale by owner, and they might say, we don't want to work with a buyer's realtor because we don't want to pay that commission. So then the buyer could choose to pay it themselves, or they might choose to just look for a different property. But I would say it depends on the person usually. The people who have done it more often might choose to do it without a realtor. Personally, I find that working with realtors is a much better experience. They're familiar with all the properties. They know all the inspectors. They know the issues that might come up, things like that. So I generally find that it's a good experience to do that, but it's certainly not required in any way. All right, so we've still got about 10 minutes, so there's plenty of time for questions. But thank you all for coming, and yeah, feel free to let me know if there's anything I missed or anything else you guys have thought of or anything like that. Yeah. Mm-hmm.
Again, on home inspections.
Mm-hmm.
So you sign the MLS, let's say I go to a real estate agent, I'm looking to buy, we sign the paper contract, and then they give me a few properties that if you wanna go look at, I do that. At what point is the home been inspected? Because in my mindset, I've sold a home before, and the real estate agent was like, based on all these factors, this is what your home should go for. And sometimes I wonder if the inspection should be done first.
Yes. So,
Does that make sense?
yeah, so there are definitely some cases I've seen where a seller will have an inspection done ahead of time. And then they might provide that to, like, say they have an open house, they might have copies of that to give to potential buyers or potential buyers' realtors, kind of as a show of, hey, you can make an offer in good faith because you know that there's no issues. Or if you know that there's a known issue, you have an inspection report done so you know exactly what the cost of that repair might be when you're making an offer. I would say usually the way it works is if you're getting an inspection done before the offer, that's usually the seller's doing it proactively. Whereas if a buyer is having an inspection done, most likely they have already signed the contract. Now the contract does have, say you get your inspection done and it shows that there's an issue with the electrical that might cost $5,000 to fix. And the sellers say, we don't want to pay to fix that. And the buyers say, well, we don't want to buy this house without getting that fixed. The contract does have ways that you can terminate the contract if you can't come to an agreement on that. So there are protections, even though that inspection is happening after you've already signed the contract.
Okay. On that same note,
Mm-hmm.
what is your recourse if you buy the house, they did the full inspection, but then a few months down the line, so this actually happened to my sister,
Mm-hmm.
she found out that the foundation was bad. So I feel like, isn't that something they check? How did you buy a house with a bad foundation and the home inspection not catch it?
Yeah. So those are the scary situations that fortunately don't happen very often, but obviously are very concerning when they do, because from a legal perspective, it can be hard to go after anyone in that situation because you don't know when exactly it became an issue. So one of the things when you sign a contract, when you sign that MLS contract, the law in Illinois requires a seller to give there are a few different disclosures. There's a residential real property disclosure report. There's a lead-based paint disclosure if the property was built before, don't quote me on the year, but I believe it's 1978, and a radon disclosure. And those disclosures basically tell the buyer, I either know that there is an issue with these parts of the house, or I do not know of any issues with these. And foundation is on there, well, septic, electrical, plumbing, all those things. So usually a seller has gone down and marked, I don't know of any issues with any of these. So say there's a foundation issue that gets discovered by the buyer 2 months after they buy. The question is, did the seller know that that was an issue and lied about it on that disclosure? In which case, then you might have some recourse against them. Or did they not know about it and the inspector didn't find it? Or it's something that came up in the last 2 months. Seems unlikely, but it's possible. Those are the situations where there's not much that you can really do without that evidence that someone hid something.
Well, because then in my mind, I'm like, did this inspector actually do the job?
Right. And the unfortunate part about that is the inspector's liability is usually limited to the cost of the inspection. So even if the inspector did a terrible job and didn't find anything, and you sue them, usually your damages would be limited to however much the inspection costs, $500 or $1,000 or something like that. So that's why inspectors' reputations, and another reason why I recommend working with realtors. The realtors have those relationships with the inspectors, and they know this is a good one. I trust them. I would work with them.
Well,
So.
the buyer also can offer to get a foundation inspection up front, right?
Yeah, so either party is usually entitled to do any inspections that they want. So the contract usually has contingencies for like a whole home inspection, a radon, those kinds of things. But a buyer is usually entitled to do any inspections that they want. So, I mean, as long as you're not hurting the property, you could have one that goes and inspects every last inch, and, it'll probably be really expensive, but if it finds something, it could be worth it. And then if they find an issue, then you could have a chance to get out of the contract before going through with the purchase.
Earnest money, I feel like I can't wrap my head around this. Like, people are selling their house and they want you to put let's go with 5K earnest money down, and then if you don't buy it, they keep the 5K?
So that's what most people think. Most people think earnest money is just if I decide, I change my mind, I walk away, they get to keep it, and we're done. That's not what it means at all. It's usually just to show that you are serious about buying it, that you're not going out and signing 10 contracts to buy houses because you're just going to walk away and dare people to sue you, essentially.
Okay, but you do buy it in this scenario, but the
So-
$5,000 is just extra.
No,
right?
so if you pay an earnest money deposit, that is deducted from the purchase price at the closing. That's credited against what you've already paid. So say it's a $100,000 house, you pay $5,000 in earnest money, then once you get to the closing, you only owe $95,000.
What about the reverse, where you pay $5,000 earnest money, but then they field like 20 offers, so they have so many people on the table, they can go with someone else?
So you don't pay the earnest money until the offer is accepted.
Oh, okay.
Yeah. So say if I make an offer on a house that says I'll pay you, $100,000 with $5,000 in earnest money, if they don't accept your offer, you don't pay that earnest money. It's not like it's included with that offer. That's taken care of after the fact usually. Joe, yeah.
First home buyer programs is could be a whole topic of it.
Yeah.
But just as a quick question, many of the benefits depend on time. I've heard people saying 2 years, but I've also heard people saying 10 years. Can you give some comments about this?
So I know vaguely of some of the programs that exist. I am not familiar with the specifics. What I can say is that the lenders are usually very knowledgeable about that. So this isn't exactly advice from a legal perspective, but just from my perspective, like when I bought my house, we went, my fiance and I went well ahead of time. So we knew we weren't looking to buy a house until, say, June of the next year. We went a whole year ahead of time and met with a mortgage broker and said, hey, we're interested in buying a house in the next, 1 to 2 years. What should we be doing now? What programs should we be looking into or applying for? And they were able to give me all that information. So that I would say, if you're interested in first-time home buyer programs or anything like that, speak with the lenders, and they usually have that information about what you might be eligible for or things you can apply for, and things like that. So yeah, those are kinds of the other entities. So, you know, there's the attorney, there's the realtor, and there's the lender that all work together with the home buyer to complete the process. And they all, you know, we work with the lenders and the realtors. We email back and forth all the time. We're almost always all in the loop on everything to work together and get that process completed. So, anything else?
What does PC stand for?
Oh, professional corporation. Yeah, that's just like LLC or, yep. All right, well, thanks everyone for coming. I'll have some business cards in case anyone thinks of anything later or anything like that. But thanks for coming, I appreciate it.